Well, today I'm gonna refer to Jackson Lewis, an article from the Wage Hour Division Administrator Wealth announced implementing administrator interpretations regarding contractor status. Contractor means when a company misclassify their worker as independent contractor. In other words, someone who work 8 hours and have an hour lunch and the company pay them for 7.5, then instead of the corporation to issue a W-2 form, the corporation gave them a 1099. And what that means is that the corporate officer did not, in fact, pay Social Security taxes, which is 6.2% for the employer and 1.45% for the employer, and the other 6.2% for the employee and 1.45% for the employer, for the employee, which is equal to 14.6%. So when the administrator interpretations from the Wage and Hour Division has been relatively faced between since the implementation in 2010. On Friday, the Administrator David Weil, speaking at a conference at New York University Law, indicate that his office will issue such interpretations to clarify who qualify as independent contractor under the Fair Labor Standards Act. It's very clear set of criteria. The Administrator Weil indicate that clarifying the interpretation will be up to deviated from the economy reality test. What is the economy reality test? The economy reality test means that only the Department of Labor and the IRS can use those tests to illustrate that district court it's right, because the district court, the department has to really get the consent, and the Department of Labor has to really make sure the tax liability is already calculated. Since the tax liability is already calculated and there were consent presented against the corporate officer, therefore the Department of Labor and the IRS can use when on cases only when the reality test can be used after the judge make the decision on the consent judgments. So now they said the test code continue to reference and analyze the issue in Gale versus Harris Nurses Registry and the Lexus 23-229 on the Second Circuit. But the retaliated application and the economy reality test under the Fair Labor Standards Act wash the space for further coverage on the federal and under state ruling by related guidance. In other words, the court can only use cases that they have an audit implemented by the Department of Labor and to have the consent judgments enforced by the judge. That's when they can use the reality test, because the crimes already committed and the judgments already enter. because the Department of Labor did the audit and they find the probable cause and they find the tax liability. They have a consent judgment between those two branches of the agency. But on the federal, it's the Social Security. On the state, it's for unemployment and workman compensations. So therefore, Gale versus Harry, the court have misclassified the law because they cannot use the economy reality test. And the economy reality test can only be used when it's done by a federal agency. If there was no federal agency involved, the reality test is not applicable, because the court cannot dictate to give a list of nurses, date of birth, social security, and the fact under the rules and regulations, because it's the called the 29216B is an enforcement mechanics by two federal agencies, which is the IRS and the Department of Labor. So therefore, the court cannot use no test to illustrate guilt of Harry's Nurses Registry and guilt of Harry DeVilliers by using Gale versus Harry's Nurses Registry. And this is the law explicit and to illustrate